Welcome to this month's edition of Stephen's Squibs, brought to you by the Center for Child Counseling. It's time to gather around the proverbial fire and discuss Florida family law cases and more. Please welcome your host, Eddie Stevens.
Hello, everybody, and welcome to our final episode of the year. This is episode number 12 of Stephen's Squib Monthly Family Law CLE. And of course, with me are CARYN and GINA, CARYN Stevens and GINA SZAPUCKI. And guys, we did it. We did a full year. We did 18 hours of board certified CLE, and we put it out every month on time. And we raised a lot of money for the Center for Child Counseling, which is really cool. So thank you guys for being part of this adventure.
And now we're on summer break for a month. Yay!
We're going to take a month.
One month recharge.
Yeah, we think we deserve a month off, and we're coming back in. We're taking August off. We'll be back in September. Everybody who can see this video can subscribe to an entire year for $200. It's going to be $300 for everybody else, but you guys get a special rate. And I don't know how many hours we're going to do. We're guaranteeing at least 15. That's what we did this year, but we created 18 hours. So we're really excited about the program and the fact that the money is going to benefit something so important like the Center for Child Counseling, who is on the front end and helping these children going through trauma. And they are also spreading the word of trauma and the impacts of it, and basically creating a trauma-informed community. And that's how we're trying to change the world, one CLE at a time. So we hope you have liked it, and we hope you guys come back and resubscribe. And I think $200 for 12 CLEs is a super price. And why not support something so meaningful, right? So today, our final episode, pretty simple. We're just going to talk about the May family law appellate cases. We have some fun ones. We have some sad ones. We have some in between. And we are going to start off with alimony. GINA, you want to talk about the first one?
Yes, we have one alimony case this month out of the 4th District. And this is based on a husband who appealed an alimony award at the conclusion of the divorce. The trial court found that based on the husband's income and the wife's need, she awarded $8,000 a month alimony to the wife to be paid by the husband. Now, the husband appealed this $8,000 alimony award for various reasons. In the trial court, both parties brought in forensic accountants, and there was a big discrepancy as to each forensic accountant and how they thought the husband's income was. For example, wife's accountant testified that her need was about $9,500 a month, and husband's net income was a little over $15,000. And husband's forensic accountant testified that the wife's need was about $7,800, and the husband's net income was a negative $2,300. So we're talking about two huge income gaps here just to start. Now, the trial court found that due to the wife being terminally ill and a few other circumstances, that she did have this need for $8,000, and because of the husband's income of $15,000 a month, he had the ability to pay. Now, the husband appealed because his main argument was that because of this substantial alimony award, with also having him pay for wife's health and dental expense insurance with no limitation and life insurance, this left him with a significantly less income than what the wife would be getting with alimony. Now, when we look to Florida Statute 6108 subsection 9, it does state that these awards of alimony may not leave the payor with significantly less net income than the net income of the recipient, unless the court finds written findings of exceptional circumstances. So based on this final judgment, all the trial court found in there was that because the wife is terminally ill and she relies on her adult children for her assistance with this illness, the trial court concluded that this is an exceptional circumstance and he pays this. Appellate court said, no, 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 this is not enough. There is no exceptional circumstance here. And furthermore, because of what the final judgment said, how the wife is relying on her adult children, the appellate court said that the court cannot look to wife relying on her adult children who assist with her terminally with her illness, unfortunately. So this was remanded back to the trial court for potentially new findings. Now on to.
And I like how in the opinion, the court did say, no, no, no. Thank you, Gina. Agreements, Sturgis. This is a kind of a weird prenup that involves a New York, a prenup under New York law. And the husband died shortly after the dissolution was entered, and there was some squabble with the estate as to whether or not the wife was going to receive alimony after the husband's death. And again, this is all New York law. I don't know how relevant this is to us, but there was a really long opinion, really long discussion. And if in New York, there are special provisions that you have to have certain language if you want alimony to continue past death. This agreement did not have that language. Also in New York, apparently any modification to a postnuptial agreement must be notarized. So the challenging spouse relied on a modified agreement, but it wasn't done with the same formalities that New York law required. So again, I don't know if this legal holding is going to be important to us, but it is an interesting long opinion about the fourth DCA interpreting an agreement under New York law and some issues that presented itself under that scenario. That's it for surrogates out of the fourth.
That takes us to appeals. We have one appeals case this month out of the first district, and this is where the appellant sought review on two non-final orders regarding visitation. Now, under the appellate procedural rules, there are a list of final orders and non-final orders of what can be appealed at certain times. Now, specifically in this case, the appellate court stated that his appeal of these two non-final orders were premature and therefore dismissed because even though the trial court entered an interim order on visitation, because they did not expressly provide any rights or obligations of either party regarding this time sharing, it was too premature and therefore this case was dismissed. Had there been those findings, we may have seen a different result from the appellate court on that issue. We now go to attorney's fees, which is number 4. Again, we have one case for this month. It's out of the 4th district. This is a case where the former wife appealed specific issues in the final judgment of dissolution of marriage. We're specifically focusing on the attorney's fees issue where the trial court found both parties should be responsible for their own fees and therefore denied the former wife's request. The former wife appealed this issue, stating that the trial court failed to make the necessary findings of need and ability. And the appellate court did agree with the former wife, where if a trial court, if someone requests fees under section 6116, in order for a court to award or deny those fees, you still have to have written findings of one party's need and the other's ability to pay. So because this final judgment simply stated each party shall be responsible for his or her attorney's fees, that is reversible error, and therefore it was remanded back to the trial court, which now takes us on to child support.
Child support, Moody v. Moody, simple holding. The court just plugged in their gross incomes, didn't take any deductions in determining child support. So because the trial court's order and the attached child support guideline worksheets reflect that the court determined child support using the parties' gross incomes without subtracting any allowable deductions, they reversed the order and remanded it for further proceedings. Um, That
We
takes
have-
us to CARYN.
Yeah, we have 2 more child support cases this month. The next one I should say is number 6 in your materials. This is the AH versus AB case. This is out of the 2nd district over in Hillsborough County. And this was a paternity matter. And at the conclusion of trial, the court made some oral pronouncements, oral findings on the record, and then ultimately a paternity final judgment, a written order, and then actually a supplemental final judgment were both entered by this court, and the findings and the written order conflicted with those that the court had made on the oral pronouncements and findings at the end of trial. And because the appellate court wasn't able to determine what the court actually meant and couldn't discern whether they wanted to follow the oral findings or the written findings that were made by this court, and they conflicted, the appellate court reversed it and remanded it back for clarification, for correction, because they couldn't determine whether it was supported by substantial competent evidence or whether it complied with 6130 and all of that. So that is the AHAB case. And number 7 in your materials is the Coffee case out of the 4th district in Broward County. And these folks had gone to a mediation, and it was a divorce settlement, and they signed a full marital settlement agreement and a parenting plan. And in their marital settlement agreement, they had some interesting language about child support, although not illegal, but interesting. And what they did is they had 2 kids, and they indicated in multiple places throughout the agreement that there were 2 children, and they indicated that child support was being calculated for 2 children. And then the language said, as in for support for 1 child, this is what the monthly amount was. But then later on in the agreement, it was indicated that the former husband, dad, was transferring the equity in the marital home to the former wife, as in for child support for the 2nd child. And it was clearly delineated in there. And even though they freely and voluntarily signed this agreement, dad appealed it later after the trial court signed the final judgment enforcing the agreement that he had signed. And the appellate court agreed and said because they had gone through mediation and they weren't contracting away child support, which we all know you can't do. And there's a line of cases that talk about that. They had contracted it just in a different way, and child support was being provided for. So the appellate court said, we're not going to disturb the agreement of the parties. So that is the Coffee case. And now we're going to move into enforcement.
In Coffee, I really liked how the 4th said, we see no reason to disturb the parties' mutual agreement for the prepayment of part of the husband's child support obligation for both of his children through the transfer of equity in the marital home that will utilize for the support of her children. So if you ever want to prepay child support, you have a 4th DCA case that acknowledges that that is a mechanism that can be done. And I think that's something else that Coffee gives us in addition to caffeine. Next case is Gibbs enforcement. We're going to talk about this in the modification world when we get to it. So this is a case that really deals with 2 things, and you're going to learn that Mr. Gibbs was not a very good person in the eyes of this court. Modification will be discussed later. He basically lived beyond his means. He transferred a whole bunch of assets to friends right before a trial, paid off contingent liabilities instead of like his alimony. And the court just basically set the purge provision as his outstanding alimony arrears. And basically the trial court found that the former husband's evidence did not meet the burden to rebut his presumption of ability. Given all the assets available to him, his immediate repayment of funds borrowed from business associates, and his more than comfortable lifestyle was within the court's discretion. I think this is an interesting case because most cases say in the purge, you have to state an actual ability, like he's got $50,000 in bank account X. And Gibbs, I think, broadens the paintbrush a little bit and allows you to do more things when you have people that are obviously skirting their obligations, still living the good life and not paying their court-ordered obligations, or prioritizing other payments ahead of those amounts. But I still think it's a little problematic because we don't have actual, findings of his ability. But that may be a good thing to help people like this, coerce them to comply with their court orders. So that's what I got out of the enforcement part of Gibbs, and we'll come back in a little bit and talk about the modification section. CARYN, income?
Under income, we're going to talk about number 9, which is also the same as number 19 in your materials. So we're going to talk about the time sharing provisions of it later on in the parenting plan. But under the income section, this is the Piccinini case. I'm trying to sound like I'm in a restaurant, but the Piccinini case versus Waxer. This is a 5th district case out of Orange County. And under the income provisions, first of all, this was a paternity final judgment, and dad pretty much appealed the entire final judgment. And a lot of it was affirmed, but there were certain issues that they looked at, which was this income issue with regard to child support, and then the holiday time sharing schedule that we'll talk about in just a little bit. But what the problem with the income here was that the court had imputed income to dad. And we all know that when you're trying to impute income to a parent who is unemployed or voluntarily underemployed or whatever you may have, you've got those 2 prongs. You've got to first prove that the parent is either, terminated or voluntarily left their employment on their own accord, or did something that was voluntary to reduce their income. And then your second prong, you have to prove that the spouse's underemployment or the parent's underemployment was due to less than bona fide efforts to try to secure some replacement employment or something of the same means. And in this case, the court made the first finding of the first prong, which was that the father had left his job voluntarily, like within days before the child was born. But there were no findings on the final judgment as to the dad not making bona fide efforts to find and secure alternative employment. So the imputation issue was problematic, and that is what the 5th district found and reversed on the child support issue. Like I said, we'll talk about the time sharing issue in a minute.
That brings us to injunctions. We have 2 cases for this month. The first is number 10. It's the Swarrick v. Lindsay case out of the 1st district. And this is, the appellant here appeals a final judgment of domestic violence with a minor child. And his grounds for appealing this final judgment is based on the sole ground that he was not personally served with the initial petition for injunction. And as we've talked about this year throughout, through everything here, injunctions are more severe. They take away someone's rights more so. So therefore, because he was not personally served in strict accordance with the statute, and there was no evidence that he had otherwise waived personal service, such as he hired an attorney and the attorney accepted service on his behalf, the court was required to reverse this ruling, serve him with proper service, and then proceed to a final hearing. Which brings us to case number 11, the Sanchez v. Sains case from the 3rd district. When I read this case, this is I think one of a little more egregious cases that have happened. Here you have parties who are married, they had 3 children, they filed for divorce shortly thereafter. Wife filed a ex parte temporary injunction for her and the party's 3 children against husband, and it was temporarily granted with a within that original 15-day deadline of a final hearing 15 days later. Now, what had happened is when the court first set this first hearing, okay, so dad received an ex parte injunction. Hearing was set for about 15 days from this injunction. That hearing never took place, okay? That hearing was extended, and what this case talks about is this case was extended for over 7 times. So now you have a husband who has received an ex parte temporary injunction, has been awaiting his final hearing, and hasn't seen his 3 children in over 520 days, where the statute is extremely clear that when a temporary injunction is entered, generally these injunctions shall not be extended more than 15 days unless there has been shown good cause why this should be extended for the parties to proceed for the final hearing. Fast forward through this case, the parties finally got a final hearing date. Dad moved to dissolve this temporary ex parte injunction. The court sua sponte the next day continued the final hearing again for over a month. The parties still showed up for their final hearing date. Both parties acknowledged to the court that they were ready to proceed to this final injunction, and it was still denied by the court. So naturally, the husband appealed this issue. And what the appellate court found is there was absolutely no good cause for this 8th extension, where dad should not have received a final hearing date. The argument was that there was good cause because there were outstanding discovery issues that clearly were related to the proceedings, and thus that's why it was continued. However, the appellate court found that outstanding discovery is a separate issue and is not good cause on its own in domestic violence proceedings, especially when both parties stated to the trial court they were ready to proceed. So therefore, the appellate court, remanded this case, even though the ex parte temporary injunction is in place. They put procedures in there that the final hearing has to happen. And I do want to note that upon this 8th continuance, I want to note that this was a new judge. So the prior 7 extensions of time were by a separate judge, and none of those orders on its own either stated good cause. That brings us to modifications.
Thank you, Gina. Some interesting injunction cases there. Modification case number 12, Hillbrands, dealt with the entry of a directed verdict, which is, always interesting on the face of the pleadings. It's not enough. So there were 2 issues. One, the former wife's remarriage, and former husband was arguing that constituted grounds for a modification of child support, downward modification. But the appellate court reminded him that he is mistaken. In fact, remarriage generally is not relevant to a child support modification. A former spouse's remarriage to a new spouse plays no role whatsoever in calculating child support. Likewise, it would be error to impute additional income to a party based on in-kind contributions from a new spouse. And that's kind of a nice summary of that law. The problem that got reversed was there was also a count that child support needed to be reduced because of mom's increased inability. At the time of the final judgment, she was imputed minimum wage. Now she had a much more prestigious job. So you can't knock that one out on a directed verdict. You actually need to take evidence. It was well pled. So in Hillbrands, the court was affirmed in part and also reversed in part, and it was remanded so they could seek that modification based on mom's income. Case number 13, interesting. It's the P.D.V-G v. BAVG. Say that real quick a couple of times. This dealt with modification of time sharing and a magistrate and a judge issue. And the magistrate found that there had been a substantial change in circumstances because of the former wife's behaviors. She had a new boyfriend, and the child was actually removed from the former wife's temporary care by the state in a dependency case. And the magistrate made very detailed findings about the best interest of the child. And the former wife was a victim of domestic violence from her new boyfriend. and there was findings that she minimized, the impact of that to her child. So the magistrate recommended a modification, went up to a judge, and the trial judge, just looked at it and said, well, the child was just removed temporarily. Therefore, I do not find a permanent change. It was a temporary change. And the circuit court judge actually granted exceptions and overturned the magistrate's report. The DCA found that the trial court erred in focusing on the fact that the removal of the children from the former wife's care had been temporary rather than the overall nature of the change in circumstances as alleged by the former husband and found by the magistrate. Accordingly, the evidence supported the magistrate's conclusion that while the removal of the children from the former wife during the dependency proceedings was temporary, a substantial change in circumstances had occurred based on the former wife's volatile relationship with her boyfriend, which continued beyond the conclusion of the dependency proceedings. Thus, the trial court erred as a matter of law in concluding no substantial change of circumstances had occurred and in granting those exceptions. So that's the end of the PBVG case. And I think 14 is an easy one.
14, yes, the Idelson versus Carmer case was withdrawn and superseded. So there will be a replacement opinion probably coming up when we get back from summer break. So you'll see it's lined out in your materials, and we'll be discussing it next time.
Can't wait.
Which brings us to case number 15, the JGJ case v. JH. Whew, tongue twister. This was a post-judgment matter where the father filed a motion for contempt against mom because mom was refusing to, dad wasn't getting his time sharing. The trial court found mom was held in contempt. However, they also changed the time sharing provision of the parties. So when mom appealed, mom was not appealing her being held in contempt. She conceded she was held in contempt. What mom appealed in this case is that the trial court erred by modifying the parties' time sharing, modifying their time sharing on a motion for contempt. And the appellate court found that mom was right for three main reasons. As a general premise, the court cannot modify time sharing as a sanction for a parent's contempt of a custody order unless the trial court can find that this change is in the best interest of the child and there's shown to be a substantial change of circumstances. So here, the trial court did not make any findings that this modification of time sharing was either in the best interest of the child, nor did it even indicate that the child's best interests were even thought about when rendering this new order. Secondly, this motion for contempt didn't allege any type of findings that a substantial change in circumstance has occurred. So like I just said, even if we are sanctioning one parent for the refusal of time sharing, the substantial change of circumstance still applies. That is not negated and it doesn't go away. And third, and one of the main, another main issue is mom was never put on notice that a modification of time sharing could be present. Although dad pled in his motion for contempt that, or I shouldn't say pled, it just said he did this on his own and he technically sought to change. The appellate court said this wasn't in his main motion, this wasn't in his prayer for relief. There's no way mom could have been on notice, and for that, and nor did dad plead any substantial change in circumstance that would warrant this change. So based on all those reasons, the appellate court remanded this for the modification of time sharing.
Cool, and that takes us back to Gibbs. The Gibbs, we talked about it in enforcement, about that Mr. Gibbs who was trying to move assets around but was still found in contempt. This is the modification side. And of course, he was saying, reduce my obligations. The trial court considered the evidence presented. found the husband had done a whole bunch of business dealings with a newly formed company, some business partners. Evidence also established he had just remarried and gifted, a bunch of stuff to his wife, including joint ownership of their residence. The former husband moved business assets between companies, received payments from undocumented sources, stored cash in a safe with business partners without reliable accounting records. That's a fun factor. And the timing of the former husband's transfers and assets and all this stuff looked like he was purposely shielding his assets from creditors. In this case, the court didn't figure out his income, couldn't, and basically found he wasn't credible, and that the court was unable to determine what his actual expense needs and ability to support himself, and denied the modification because he has the burden to prove a substantial change, and the court just threw their hands up and didn't know what to do with them. So again, on the modification part, you got denied. On the contempt part, even though you don't have actual ability, you have the full purge being sustained. And that's the end of Gibbs.
So our next case is number 17, and it's the Villalba case. And this is out of the 4th District here in Palm Beach County, where we are. And this was another modification case. And what the dad had filed a petition for modification of the final judgment about time sharing and child support if time sharing was changed. And there was a final judgment in 2016, and dad had roughly 20% of overnights with the minor child. And what dad alleged as the substantial unanticipated change in circumstances in his petition was that at the time of the final judgment, dad was living with his parents and didn't have a separate bedroom for his child. So he pled in his supplemental petition that he only agreed to 20% of the overnights at the time because he just didn't have the proper accommodations for the child. And now dad's coming back 4 years later and telling the court, hey, I moved out. I got an extra bedroom. And because of that, I want 50-50 time sharing. And these modification cases that we all see come across our desks and in our offices all the time, clients wanting more time. And we have those hard conversations with clients all the time is, when you're looking at the factors and the substantial burden that we've got to prove on a modification, just because you're a good person and just because you've got these things that you think are important, they don't always meet that statutory burden and to get over the hump to sustain a modification. And in this case, Mr. Villalba learned that hard lesson. The court dismissed his supplemental petition because mom filed a motion to dismiss it and said there was no substantial change, and the trial court agreed with it, and then the 4th District agreed with it as well. And they went on to say about, again, discussing this huge extraordinary burden that is put on the movement in a modification action, and the statute and the way that it was, they said that this just wasn't a substantial change. So sorry, Mr. Villalba, but the trial court was right on this one. So interesting read, especially when you're dealing with those difficult modification requests by clients.
And I would suggest you're going to see, if you're studying for board cert, Villalba is one of those cases that when they come up, usually you see some type of question like that on the board cert test. So take special note of that case. Plus it's, it restates it in a way that's very clear, and it's probably going to be the 4th DCA case on that issue. Our next modification, case number 18, Valby. God bless Mrs. Valby for making some really interesting, unique arguments that we get to talk about now. So she was kind of upset that her alimony was reduced from permanent to durational. And she argued with the appellate court, and initially argued that the trial court could not modify her alimony from permanent to durational because durational alimony did not exist at the time of the original alimony award. Kind of interesting argument, right? In support, she relied on the session laws of the alimony statute, which state the amendments may not serve as a basis to change amounts or duration of awards. However, the amendment to the statute was not the basis for changing the duration of the alimony award. Rather, the alimony award was modified based on a substantial change of circumstances as permitted. So it wasn't just like, hey, the law changed. It was part of his case. Then the trial court, they argued, did not modify alimony retroactive to the date of the final judgment, but rather to the date of, well, they explained that the court didn't go back to the final judgment, it just went back to the date of filing. Durational alimony did exist as of the date of filing, so apparently that was okay. The former wife then argued that per 61.14, the court only had jurisdiction to modify the amount, and it did not have the authority to modify the type of alimony awarded. And that's not right. That's just an erroneous argument. And it's kind of interesting that the court cited the Rosen case that we all know, and we all understand Rosen to be an enhanced fee case. And a lot of people misuse it as a vexatious litigation mechanism to get fees, but it really doesn't say that. But Rosen also addressed this alimony issue before the Supreme Court way back when. And then the Supreme Court said a trial judge has the authority to alter alimony from permanent to rehabilitative. So if the court can do that, certainly they can change it to durational. The wife then suggested that the court overlooked that the fact that her needs had changed, and she had $80,000 of needs as a result of debt accumulated from this proceeding. The court found that I'm not going to look at the $80,000 in debt that you incurred with your attorney's fees, because there's other ways to address that. You can seek to have your attorney's fees reimbursed if you want. So it's not we're not going to use that as a credit to your need. But there were some alimony expenses that just were not addressed. Not much, a couple dollars here and there, like the cost of electricity, water, a couple categories, $30, $140, $400. So the court was remanded to explain why these few dollar categories were excluded from her needs. So an interesting case. The main meaning is if you have a financial devastation due to litigation, that's not a basis for modifying alimony, because the courts are going to see that as a temporary issue in accordance with the Valby case.
It was a really good try, though.
She tried so hard.
Really good try. Go, Mrs. Valby.
I think we're back to your
Go ahead. You need to soprano that name for us. Come on.
Pissanini.
There we go.
And I can't wait, not that this name has anything to do with The Sopranos, but The Sopranos are coming out with a prequel on HBO Max.
Yes.
If you haven't seen, we digress. But a trailer just came out and it looks much better than I ever thought it would.
We're not being paid any commissions for promoting it, just so it's clear.
We don't get paid anything for this. We're just chatting.
So Mr. Piccinini and his former wife, Miss Waxer, or former VV mama, Miss Waxer. So we're back to that case. Now we're at number 19, and we're dealing with the same case under the parenting, and we talked about it a few minutes ago. And the final judgment of paternity had some interesting language in it about holiday time sharing, and it said, if the father should want time with the minor child during a specific holiday, the father shall obtain the consent of the mother at least 2 weeks in advance of the holiday. So the trial court, that's what the trial court order says. And the appellate court said, well, that's kind of improperly placing dad's right to holiday time sharing with his child essentially in the hands of the mother alone and not within the discretion of the court. So it gave mom way too much control to decide, no, not having Christmas because I decided no. And because of that, the parenting plan issue on holiday time sharing was reversed in Mr. Piccinini's case.
And Mr. Piccinini tried so hard to reverse all these other aspects. Like he appealed the fact that there was an unreasonable delay. He appealed the fact that he had supervised visitation. He appealed the fact that the court allowed the relocation. He appealed the fact that the court did not provide specific steps for him to obtain unsupervised time sharing that we talked about in the CNIGC Supreme Court case from last month. And all of them were rejected. But they gave Mr. Piccinini a sliver of hope when it comes to holiday time sharing by not putting his ex-wife in charge of his access.
He gets Christmas and they fixed his income, and there we go.
Gina, I think you're up next.
I am.
Summary. Come on, it's quick. Christmas and fix your income. There you go.
I like how you brought that all together.
Yeah.
Full circle. Which now we're on number 20, the Amoy v. Olmsted case. It's out of the first district. This is a case where the former husband appealed a order modifying time sharing. A little background here: the parties were married. They entered into an MSA, which gave them equal time sharing of their minor child. However, shortly after, the former wife received a military order that she had to transfer out of state. So she filed the appropriate motion pursuant to the relocation statute for a request from the court for her to move with the minor child to California. After hearing, the court denied the relocation, but they did modify the time sharing plan under the final judgment. So what they did was, while this minor child was still in preschool, the parties get equal time sharing. And when he enters first grade, dad would have majority time since he's still residing here and mom was in the military and relocating. But what the court also did is they made a conditional provision where, in the event mom comes back or relocates back anywhere within, they said, I believe it was 60 miles of the county where they're both residing now, then the agreement goes back to how it was and they both get 50-50. So the former husband appealed on this prospective modification of time sharing. And what the appellate court said is that the trial court has to determine what's in the child's best interest at the time of the final hearing. And what I love that they referenced in this case is that the Supreme Court has explained a trial court is not equipped with a crystal ball that enables it prophetically to determine what the future relocation is in the best interest of the child. May have butchered that, my apologies. However, what the court did is they reversed it in the sense that because they found this was a prospective potential change, the trial court can't do that. And it also would deter a requirement that every parent has to follow to filing a relocation. So if the appellate court agreed with what the trial court did, not only would it be a prospective change of time sharing, but mom would never have to file another petition for relocation of her address. So for those multiple reasons, that portion was reversed in part.
I really wonder what the long-term impact on reunification plans that this new type of law that we're seeing since the CG case from the Supreme Court in April, it seems like the trial court is losing its ability to really engage in structuring that type of restoration of time sharing, and probably will have to be done during a pending case before you get to final judgment, and have those reunification steps be part of a temporary order. Because if you're trying to accomplish that reunification post-judgment, I think these cases are really tying the hands of these judges and what they can do. So I think we're going to see a lot of resistance with people using these cases to kind of block having these changes embedded in a parenting plan that allows someone to have that time sharing. And I think there's still that issue from the CG case where, the Fifth said we can't even do steps, and the Supreme Court didn't pass on that yet, but all the stuff is ripe to be decided. So Gina, really good job explaining that one.
Thank you.
21, is that you or me, CARYN?
That's me. This is the Ruschel case. This is out of the first district in Alachua County, and as a very proud Seminole alumni. It always, every time I see Alachua County, it makes me think of the joke I learned when I was a freshman, which is the only good thing to come out of Alachua County is I-75. So for all of you Gator fans, you're welcome. But nonetheless, I love that one. So I was reading this, and why it's even funnier in this situation, sorry, Alachua folks, is that in this case, Mr. Royschel is sitting in jail, serving a 30-year sentence for trying to kill his wife, murder his wife. So he's a super cool dude. And of course, the appellate court's opinion says that he's sitting in jail serving this 30-year sentence for attempting to murder Susan, his wife, which of course prompted her petition for marriage dissolution. So in case there was any questions, but this is a very short opinion, and it actually falls under the procedure section, and everything that I told you had nothing to do with anything about procedure, but it was just sexy and salacious and fun. So what the Royschel case stands for and teaches us is that these folks owned a dental practice. Husband was a dentist before he decided to have alter, skill sets and go after his wife. But they owned a dental practice called Sapphire Dental LLC. And there was no question that the dental practice was a marital asset. And the husband and the dental practice hired the same lawyer to represent themselves in this pending dissolution of marriage action against Susan, the wife. And Susan, through her attorneys, filed a motion to disqualify the law firm who was representing both parties. And by the time this got to the trial court for actual adjudication on that motion, the custodian who had been appointed to operate the dental practice while Mr. Royschel sat in jail had already hired a new law firm to represent the dental practice by the time it got in front of the trial court. And because of that, the trial court ruled that Mrs. Royschel's motion for disqualification was moot and got appealed. And at the end of the day, the appellate court said it was moot because there was already the disqualification, conflict of interest had already gone away. There were two separate lawyers by the time. So that is what the Royschel procedure part of that case is.
Delgado, number 22, dealt with how you bring up latches in an enforcement issue. And in this case, there was a contempt issue, and it was 22 years after the kid hit emancipation, but technically dad still owed some money. And part of the case talks about his unilateral gifts to the child not being counted. But he raised at the hearing the defense of latches, and the court wouldn't consider it. So the court got reversed on this issue because he raised it at the hearing. I guess it's not an affirmative defense that needs to be pled because a motion for contempt is a motion, not a pleading. And he was remanded back, and the court had to deal with his issue of latches that he raised. It's Delgado.
So the next case, still under procedure, is Bedwell versus Bedwell, 2nd District case out of Lee County. This was a divorce action, and the original case was heard by Judge Hayes. And Judge Hayes entered a final judgment back in 2018, but coincidentally, there was a bankruptcy action pending at the same time as the dissolution of marriage action. And when the bankruptcy court found out that Judge Hayes had entered a final judgment in 2018, the bankruptcy court said, hey, final judgment's null and void as to any property distribution matters. And then there was a stay entered on the final judgment in the divorce matter until the bankruptcy proceeding was resolved. And 2+ years later, bankruptcy case is ultimately resolved, stay is lifted, and now it proceeds back to the circuit court for the dissolution action to be finalized with the final judgment. And as luck would have it, of course, Judge Hayes had rotated out of the family division into the circuit civil. And now we had Judge Swift, who by her own name was quick and swift in this action. And she entered a divorce judgment upon getting this case back in her hands in her division that was identical to what Judge Hayes had entered in 2018. And interestingly enough, Judge Swift signed it as Judge Hayes for Judge Swift for Judge Hayes. And the former husband appealed this issue, and there's an entire discussion in here that when there's oral testimony produced during a trial in front of one judge, and then another judge comes in and enters a final judgment later, unless there's a stipulation on the record as between the parties that this is okay if another judge can't come in and render a verdict when the testimony was heard by someone else. So the whole 4 by Judge Swift was improper. This was reversed, and a new trial had to be conducted de novo in front of now Judge Swift. Sorry, not sorry, that's how that works. So there's some interesting case law, and it cites to the Fry case, which is the 2nd District case, and the Bradford case about having the authority of a successor judge and what they can and can't do. So had they brought them in and everybody stipulated that Judge Swift could assign this, that would have been fine. But because that wasn't done, the final judgment was improper. And that is the Bedwell case.
I think they should call it the Swift case.
The Swift case. It was Swift.
So the next case is again under procedure, Jean v. Jean, and I've been waiting. When I read this case, I texted CARYN saying we finally got the case we were looking for. And Jean teaches us that when you take exceptions of a magistrate's report, the party seeking review of the report and recommendations to have a requirement to file the transcripts if necessary for the court's review. So if exceptions raise pure issues of law, such as whether a report improperly modified property rights, that would be an error on the face of the judgment. And just recently we had an exception hearing, and I was looking around for this case. It didn't exist at the time because I didn't want to spend hundreds of dollars on the transcript because it was a legal error that we were easily able to fix. But I had to order the transcript because we had yet to have the Jean case. So I'm very, very, I can't believe I'm excited about a case, but I'm glad to see Jean came out. And I did text CARYN when I read it.
You need to star and highlight this one for those of you who are dealing with general magistrates all the time and these transcript issues. I've seen pro se litigants and other people get their exceptions dismissed because they don't give a transcript. So it's a good case, and Eddie was properly excited about it. So
yes, so there we go. Now we're in the Dada Panini case, right? The Dada Panini case. It's like the Piccinini case, but the Dada.
We're both sitting in an Italian restaurant.
I have to use the Italian hand.
We have to be careful, guys. We also don't want to get in trouble for our humor, but we're just trying to have a little fun too. Back on topic. So this is an injunction hearing, and at the end of the case, the judge said, well, if I freeze this money, the wife's not going to have access to it. So instead of freezing it, I'm going to make her a joint title holder. And that was not noticed. And the former husband kept saying, I'm not trying this issue by consent during the hearing. And if people are trying to jam you up with unpled issues, I would vocalize. I always love saying on the record that I am not trying this issue by consent, because I think it crystallizes it, as opposed to just objecting to the entry of the evidence. And it worked. The court was overturned for exceeding the scope of the motion. And it was kind of cute. The trial court said, well, the wife did request all other relief appropriate. That little sentence you throw at the end of the wherefore clause, but that sentence not enough to give a court unbridled jurisdiction to do whatever they want. I don't even know the legal relevance of having that in pleadings anymore, especially when you have Dada Pini to block them. Dada Pini. So throw that in your procedural arsenal of cases. Some real fun cases this month. Finally, last but not least, the last case we're going to talk about in season 1 is the Velez v. LaFontaine case out of the 5th. And this dealt with a contempt hearing. And at the end of the contempt hearing, the judge changed the kid's school and distributed costs of daycare, because now the kid would have to go to daycare because the judge unilaterally changed the school. Again, this was not pled. No one had notice. And basically the appellate court found that the trial court violated the father's due process rights by granting relief not requested by the pleadings or providing notice to the parties. So we have had a lot of cases like that, scope of the motion type cases, tried by consent. Our favorite practice tip, if the other side is not objecting, jam it all through. If you're the one defending, be sure to vocalize the appropriate objection and say on the record, I'm not trying this by consent. I think it's a good practice tip.
And I just want to say, I think what was really interesting in this Velez case, and I think it's really a nice way to end this season, is that the appellate court had language in their opinion that said, we recognize that domestic relations cases, especially those involving children, often pose unique difficulties for trial judges. The reality is that far too often the parties are simply unable to resolve disputes amongst themselves, leaving judges to make decisions concerning the best interests of children that they have never met. And I thought that that was just a really good summarization. And Eddie had talked about that with the Valby case a minute ago. And just like, you know, these courts are really trying, and the problem solving that they do. And we really thank our benches and our judiciary for always doing the best that they can and trying to do the right things for these families. But I just thought that was a really good summarization of what we deal with every single day.
Yes, and obviously the courts don't have the tools to do what's in the absolute best interest for these kids. Only the parents do. Unfortunately, we are in a world where parents are not always doing what's in the best interest of their kids. And that's why I guess we're all so busy. So we did it, guys. We created 18 hours of CLE in a 12-month period, and we did it on time. And I am so proud of you guys, and thank you for going on this journey with me and helping me raise money for a really good cause. And we really hope all of you all tune in next year, because I think we learned something this year, and next year it'll even be better. And we plan on having a whole lot more guest stars, and we thank everybody that has participated, all the board cert tips, the living legends, RT White's constant involvement, and everybody else that came on to talk about cases that they were involved with. It was a really fun year, and we hope that you guys got something out of it. So without further ado, we'll see everybody on September 15th. Have a good summer.
Thank you for joining us for this month's edition of Stephen Squibs Monthly Family Law CLE. We hope to see you again next month. In the meantime, do something that matters. Visit www.eddiestevens.com for more information.